The House will come to order. Members will be in their seats. The clerk has opened the roll and you may record your presence. Please rise and give your attention to our House chaplain and remain standing for the Pledge of Allegiance, led by Representative Keither.
Let us pray. Almighty God, we thank you for this day and the pleasure of being back here with our leaders. Thank you for handling well the pressure the body put on you and me to represent them at the Super Bowl and to bring a victory home. There were a few lessons I was reminded of at the game that can be applied here as our leaders work together. Never quit. Never give up. When things are not going well, it is essential to assess, adapt, and overcome. Perseverance always pays off, so it is imperative to get up whenever knocked down and try again. To reach the end goal, one must keep focused on that goal. And two people can be on opposite sides and understand they will never change. Yet when all is said and done, they can shake hands and have mutual respect for each other. Teach us these lessons, O Lord, I pray. Amen.
Have all members had the opportunity to record their presence? The clerk will close the roll and record the attendance. Introduction of bills and concurrent resolutions. The clerk will read.
House Bill number 2568 by the Committee on Transportation, an act concerning traffic regulations relating to speed limits, allowing local authorities to decrease speed limits without an engineering and traffic investigation. House Bill number 2569 by the Committee on Transportation, an act concerning motor vehicles relating to antique vehicles, allowing model year vehicle dealer license plates to be displayed on antique vehicles. House Bill number 2570 by the Committee on Health and Human Services, an act concerning health and health care relating to certain prescribers, limiting certain prescriptions to a 7-day supply exceptions. House Bill number 2571 by the Committee on Federal and State Affairs, an act concerning licensure under the Club and Drinking Establishment Act. House Bill number 2572 by the Committee on Education, an act concerning teachers, creating the Educator Protection Act relating to excess professional liability insurance coverage for teachers. House Bill number 2573 by the Committee on Education, an act concerning education relating to curriculum for civics, requiring students to pass a civics examination for high school graduation. House Bill number 2574 by the Committee on Education, an act concerning health and health care relating to the School Sports Head Injury Prevention Act, requiring schools to establish concussion management team standards of care protocols required by biennial education. House Bill number 2575 by the Committee on Agriculture, an act concerning public health relating to the Kansas Dry Cleaner Environmental Response Act, the payment of certain costs of remediation of pollution from dry cleaning activities, deductible amounts, penalties for violations. House Bill number 2576 by Representative Adam Smith, an act concerning property taxes, requiring tax bills to be mailed before December 10th each year. House Bill number 2577 by Representative Riley, an act relating to the taxation of motor vehicle fuels, providing for a county option. House Bill number 2578 by Representatives Capps, Blex, and others, an act concerning sales taxation relating to exemption, farm products sold at farmers markets.
Message from the Senate. The clerk will read.
Announcing passage of Senate Bills 157 and 258 Senate Bill number 157 by Senators Hildebrand, Alley, and others, an act concerning family law relating to temporary parenting plans. Senate Bill number 258 by the Legislative Post-Audit Committee, an act concerning the Legislative Division of Post-Audit, removing the requirement to submit certain reports thereto.
Introduction of original motions and House resolutions. The clerk will read.
House Resolution number 6030 by Representative Concanon, a resolution recognizing February 6, 2020 as Wear Red Day at the Capitol.
On H.R. 6030, the chair recognizes Representative Concanon on a motion to adopt the resolution. And Representative Wassinger.
Thank you, everyone. First of all, for all of you who wore red today for heart health, I appreciate it. Today with us is Michelle Shump and her daughter Allie, our heart warrior, and Susan Omari, who is also part of the Heart Warrior group. Thank you. Thank you for being here.
Mr. Speaker, the following is a resolution recognizing February 2nd, 2020 as Wear Red Day at the Capitol. Whereas heart disease and stroke kill 1 in 3 women in the United States, yet 80% of cardiac events may be prevented through education and lifestyle changes, such as moving more, eating smart, and managing blood pressure. And whereas cardiovascular disease and stroke kill 1 woman every 80 seconds in the United States, and cardiovascular disease kills more women than the total combined deaths from cancer, accidents, and diabetes. And whereas nearly 45% of women aged 20 and older live with some form of cardiovascular disease. Women having heart attacks wait 30% longer than men from the moment they begin experiencing symptoms to the time they arrive at a hospital. From arrival at the hospital to the moment women start receiving care, women experience 20% longer wait time than men, and women are also less likely than men to receive bystander cardiopulmonary resuscitation. And whereas 57% of African American women with 40% and 40% of Hispanic women aged 20 and older have cardiovascular disease. And whereas for Caucasian women, cardiovascular disease claims the lives of more women than all forms of cancer, including breast cancer, Alzheimer's disease, Parkinson's disease, motor vehicle accidents, and unintentional injuries combined. And whereas heart disease and stroke can affect a woman at any age, and new research shows heart attacks are on the rise among younger women, which serves to emphasize the importance for women to take charge of their heart health. Now, therefore, be it resolved that the House of Representatives of the State of Kansas, that we recognize February 6, 2020 as Wear Red Day at the Capitol by wearing the color red to raise awareness of the importance of the ongoing fight against heart disease and stroke. And we urge all citizens to show their support for women by commemorating this day. And be it further resolved that the Chief Clerk of the House of Representatives shall send an enrolled copy of this resolution to Representative Concanon. Mr. Speaker, I move to pass House Resolution 6030.
You've heard the motion. All in favor signify by saying aye. Aye. Opposed, no. Motion carries. The resolution is adopted. House Bill 2466 appears on the consent calendar for the first day. Is there objection? Seeing none, it will remain on the consent calendar for the second day. The chair recognizes Majority Leader Hawkins to motion to resolve to the Committee of the Whole.
Thank you, Mr. Speaker. I move the House resolve itself into the Committee of the Whole for the purpose of considering those items under the heading of General Orders.
You've heard the motion. All in favor signify by saying aye. Opposed, no. The ayes have it, and the motion carries. The chair appoints Representative Prail to chair the Committee of the Whole.
Good morning, body. First item of business is Senate Bill 155. For the purposes of carrying Senate Bill 155, the chair recognizes Representative Hubert.
Thank you, Mr. Chair. All right. I am the opening act, and I'm going to keep this short because we have a full day in front of us. Senate Bill 155 was on consent calendar last year, and it got pulled off on the last day, and so that's why we're here today. But I've been working on this issue for a long time, and 2016, revisers told me there needed to be legislation to deal with this issue. The City of Valley Center had tried to work on this without legislation, and so in 2017, a bill dealing with this issue passed this chamber 125-0. For those of you who don't like get and goes, this bill was a part of that ugly experience, and ever since then I've been trying to get this bill to the governor. Today could be that day. So the senator from Sedgwick that represents the community of Sedgwick and I have been working together, and she did also work and get agreements as far as the cemetery and the city of Sedgwick on what you have before you today. And again, when legislation was first passed on this taxing district for the cemetery, they drew the lines to the city limits of Valley Center 75 years ago. And Valley Center has grown a lot. And so a lot of Valley Center grew into this taxing district. And so all this bill does is that anytime Valley Center grows, it will keep Valley Center territory and the people in the Valley Center out of this taxing district in the future, and it just stops people from having to pay taxes for both the City of Valley Center Cemetery and for the one in Sedgwick. And again, I believe this has been thoroughly vetted, and it is no opposition, supported by all parties involved, and I would ask for your support, and I would stand for questions.
Does any member desire to speak to the bill? Seeing none,
Thank you.
Representative Hubert, you may
Thank you.
close.
All right. I'm going to go ahead and close, and Mr. Chair, I move that when the committee rises in the report, it reports, and this is Senate Bill 155, favorable for passage.
You've heard the motion by Representative Hubert to report Senate Bill 155 favorably. All those in favor signify by saying aye. Aye. Opposed, nay. The ayes appear to have it. The ayes do have it. Motion passes. Next item of business is Senate Concurrent Resolution 1613. For the purposes of carrying SCR 1613, the chair recognizes Representative Humphreys.
Thank you, Mr. Chairman. Today I bring you SCR 1613 to amend the Constitution of the state of Kansas by adding a new section stating that there is no right to abortion in the Kansas Constitution. It would submit this proposed language to the qualified electors of the state for their approval or rejection at the primary election in August of 2020. If passed, if passed by the majority of electors, the language would be added to the Kansas Constitution saying there is no right to abortion and saying that the people of Kansas may regulate abortion through their elected senators and representatives. So why are we bringing this today? We are going to probably talk about it for a long time today, talk a lot about it. So I'm going to be brief in introducing it because I think you'll hear a lot as the day goes on. What I will say is what this does and what this doesn't do. What it does is it sends this decision to the people of Kansas. What it does is it will keep our regulations in place that we have for the safety and health of mothers and the unborn. What it does not do is ban abortion. What it does not do is take the legality away of getting an abortion in the state of Kansas. What it does is it keeps the constitutional, it keeps the laws that we have passed already for the safety and health, such as consent, informed consent, consent of parental consent, health and safety standards. It keeps those in place if passed so that women and the unborn can be kept safe. So at this point, I will open this up. I will stand for questions, and I will be happy to answer any questions, and let's just get this discussion going.
Chair recognizes Representative Arnberger.
Thank you, Mr. Chair. I remember the day when I learned about what an abortion is. It was a Sunday evening in December. I was 14 years old at youth group, and we were talking about the March for Life event at the Capitol. Our youth group leader educated us about the event, about the topic, the beliefs on the Catholic faith, and then sent around a sign-up sheet to see who all wanted to participate. I grew up in a household where I had to ask my parents' permission before I could leave city limits. So that night, my mom and I talked about it. I was confused, intrigued, upset, devastated, and tears were shed. Not just for me, but for my mom as well. I was 14 years old when I had this tough conversation. I remember when I was 17, and I had a heated conversation with a fellow classmate about the right for life. I remember she made the comment that, and I quote, "Her life would be ruined if she had a baby this young." Ruined. That word stuck with me. I've always thought babies were a blessing, and to say "I don't want you" is heartbreaking. Throughout all my research on this constitutional amendment and learning about pregnancy and abortion in general, I've had a roller coaster of emotions. And since my mom and I are still close, 12 years later, we had this conversation again, almost identical to the one we had when I was 14. I called her on Tuesday when I started writing this out and asked her if she had any advice for me. She just told me, "No matter what you say, the press is probably going to beat you up for it." Well, I stand here today to tell you that I am in support of the constitutional amendment. That baby, or to say a baby isn't a human or a person until they're born, is just simply naive. That baby is growing. That baby has a heartbeat. That baby is growing ears and toes and fingers and a nose. That baby is about to change your life. On your desks, I have placed a baby growth chart. I'm not pregnant. Everybody keeps asking because I place this. I'm not. Each day, a baby grows. So to say, just to name a few, at 8 weeks, a baby is the size of a raspberry. At 13 weeks, a baby is the size of a peach. At 16 weeks, a baby is the size of an avocado. And at 20 weeks, a baby is the size of a banana. As a member of the Federal and State Affairs Committee, I sat through the lengthy hearing and vigorous debate in committee when we worked this bill. It was said numerous times that Kansans will get confused about this amendment. How insulting. Kansans are smart. Kansans understand this issue and they want to vote on it. Why are you stopping them to do so? If you truly believe Kansas is a pro-choice state, then let them vote. If you truly believe that Kansas is a pro-life state, then let them vote. Many of you may have known or found out that I am engaged in planning my life with my future husband. In November, we went to Engaged Encounter in Wichita. Throughout this weekend, we grew stronger and discussed our plans for our future. I'm so excited to start a family with Justin. I just keep thinking about how great it's going to be to have a little one or two or maybe three running around our house. I keep thinking about all the cute baby clothes and how I can't wait to find out what type of gender we'd be having, and also telling our parents and seeing their faces. I think about how much fun it'll be to watch them play sports, attend their band concerts, and helping them with homework. I also think how great it'll be to have someone unload the dishwasher and take out the trash and mow the lawn. It just breaks my heart that some folks do not want this experience because it'll ruin their lives. I just want to end with this quote that I found one day. How cool is it that the same God that created mountains and oceans and galaxies looked at you and thought the world needed one of you too? Let Kansans vote on this issue. Thank you.
Chair recognizes Representative Erickson.
Thank you, Mr. Chair. I believe that there is and should be more that unites us than divides us, even on this issue. I venture to say that all of us have women that we love and care about very deeply, whether that's a wife, a sister, a niece, or as in my case, a mother, a daughter, and a granddaughter. When I was a teacher and principal dealing with students in difficult situations, my rule of thumb was always to treat them as I would want my own son or daughter treated. And that's what I want us to think about here today. Picture your loved one as a 16-year-old hurrying to get out the door to school a little bit earlier than usual. She heads straight for the bathroom, closes the stall door, slides the lock, and pulls a home pregnancy test out of her backpack. In my experience as an administrator, this has happened more times than I would like to admit. She waits for what seems like an eternity and she looks down, and it's positive. Imagine the emotions and thoughts that run through her mind at that time. Probably fear, shock, complete and utter panic. And how would you feel when you find that out, that she is pregnant? You probably would have a lot of those same emotions. But would you love her any less? Of course not. Wouldn't you want the best care for her emotionally and physically? Of course, we all would. And what if she chooses abortion? The same decision she could make before the Supreme Court ruling, and the same decision she will be able to make after this resolution and constitutional amendment passes. She opens the door to the clinic, and that's where we come in. We can act to guarantee the safeguards that she deserves. Common sense, basic safeguards, such as making sure that the premises and equipment are clean and sanitary, that the practitioner is competent and qualified, and that there should be consequences for engaging in conduct likely to deceive, defraud, or harm the public, or demonstrating a willful or careless disregard for the health, welfare, and safety of a patient. You see, these regulations passed out of this chamber unanimously. Now, before you all hit your buttons and come up here and say, Representative, because I hear the murmurings, that's not true. That's not true. You're absolutely right. We have never unanimously passed regulation on abortion clinics. I was referring to veterinary clinics. You see, these regulations passed unanimously with 0 no votes in 1969, the same year we passed abortion rights. Please don't misunderstand me. Our pets deserve safe and competent care. How much more so do our loved ones and all women deserve that same consideration? I want to share an email I recently received. When as a student nurse in the 1950s, I cared for a beautiful 16-year-old girl from Topeka who had a back alley abortion. She developed a septicemia, ran high fevers, and the stench coming from her room lingers with me today. She didn't make it. She died alone. This should never have happened, and we should make sure that it never happens again. Not in Kansas, not on our watch. There's another important part to this resolution that should unify us, and that's the right of the people of Kansas to vote on whether or not they want their elected representatives to be able to protect and put these safeguards in place. Why would somebody be opposed to this? In the joint hearing of the House and Senate committee hearings, we were told why. They said that the voters of Kansas will be confused and won't be able to understand this 9-sentence amendment. Isn't it ironic that some of those representatives here today will support suppressing Kansans' right to vote on a woman's issue in the same year we're celebrating the 100th anniversary of women's right to vote? These are the same people who will be coming to your doorstep asking you to vote for them for re-election. I'm confident the Kansas voters will not be confused and that they do fully understand. To my fellow pro-life colleagues who claim that this resolution doesn't go far enough in protecting the lives of the unborn, and to the pro-abortion colleagues who think it goes too far, that's a debate for another day. This resolution before us does not restrict a woman's ability to choose an abortion, just that if she does, she deserves basic safeguards for her health and well-being, and that Kansans should have a say through their constitutional right to vote. On that, we should all be unified and should all agree. Thank you, Mr. Chair.
Chair recognizes Representative Concanon.
Thank you, Mr. Chair. I come before you today to share my support of the proposed constitutional amendment. I think it's easy to get sidetracked on why this amendment is necessary. My support for this constitutional amendment sits entirely in my trust of the legislative process. Without this added language, previous legislative action that has passed by large margins in this legislature will lose relevance. The legislature will no longer be afforded the opportunity to pass laws, to regulate, and to exercise oversight of the abortions performed in this state. A constitutional right for an abortion, as deemed by the court, will compel us to spend Medicaid dollars on the procedure, something we have clearly stated would never happen. A conservative state like Kansas should not be spending public money on abortions. And if we do, we should let the people of Kansas make that decision. This does not ban abortions or even take baby steps toward it. It simply allows this new language to be on the ballot for the people of Kansas to have a voice in protecting legislative actions and to have a voice in how we spend tax dollars. So I ask you to vote yes to get this on the ballot and trust the people of our state to make the decision that is right for Kansas. Thank you, Mr. Chair.
Chair recognizes Representative Luis Ruiz.
Thank you, Mr. Chairman. We had a lot of good information passed through our Fed State Committee back in January, very compelling on both sides of this issue. Whether you believe in women's choice, just because you believe in women's choice doesn't mean you think automatically abortion. I think that's kind of a misconception. Because you're pro-choice, you're pro-abortion. I'm not. I'm for a woman's right to choose. That's the way I was brought up. Even though my religion may tell me something different, I stick to the guys under, I talk to my wife as a physician, my daughter represents nurses. So I've kind of geared towards living and watching them make choices for themselves. I'm not educated in the medical field. I don't know what goes through a woman's mind when she becomes pregnant, if it scares her. A lot of times they're elated. I know when my kids found out my family was pregnant, my wife with my kids, I was happy. Great. But my wife did lose a child. She miscarried, which broke my heart because I was looking forward to the third child. In some states, that might have been considered a heinous act and maybe been investigated. And I think if we pass this regulation under this guise of a constitutional amendment, we're opening a door, maybe a Trojan horse, to do away with abortion altogether, to do away with a woman's right to choose. I fear, and even in committee it was said, that question was asked, will this ban abortion? No. Is it a possibility to ban abortion? No, it's not in the amendment. So with that, Mr. Chairman, I would like to ask the carrier of the amendment to please stand for a few questions. Good morning, Representative.
Good morning.
Representative, again, could you explain to me why this is good?
Yes, I certainly can. That decision in April of 2019 found that there's a right to abortion in the Kansas Constitution, but that's not all it did. It also sent back the dismemberment abortion that had been passed out of this body to the lower court, saying that because abortion is a fundamental right in the state of Kansas, that now any regulations we put in place must be argued, must jump over a very high hurdle of strict scrutiny. So any regulations that this body has put in place, I think there's like 19 for the health and safety of the mother. When we put them in place, there was just a standard that the court looked at, undue burden, like it looked at different, which is better? Is it okay for the mom? Is it, whose interest does it matter? But when they put this very high standard, suddenly the underpinnings of all of those regulations are gone. And so therefore, if challenged, any informed consent for the mother so that she knows who is going to be doing the abortion. Parental consent, so your 14-year-old can't be taken to the abortion clinic either by a trafficker or by her counselor. 24-hour waiting period so someone can't drop someone off and push them in. All of those things that this body put into place to protect these women, now those underpinnings are gone. And that's why we feel it's so important that we pass the amendment that says we're not going to look at abortion under this highest standard. We're going to go back to where we were before. We're going to keep those regulations in place for the safety and health of the mother.
Thank you, Representative. That was a good answer. So in essence, what you're telling me is that the Supreme Court of Kansas in 2019, by saying that a woman had the right under the Constitution to control her own body, is not what this amendment would do. It strips the courts of that right to do that, or their ruling under that. It'll make it moot.
Thank you. I would say two things. A woman has a right to know who's going to be doing her abortion. A woman has a right to know what she's facing. Parents have the right to know what's going on with their children. And a woman in Kansas has the right to an abortion, even if we pass this amendment under the federal Constitution. We're not taking the right to an abortion away. It's still legal in Kansas.
Thank you. But in the future, if we take the power from the courts, the Supreme Court, to regulate and takes it to the legislature, that right for a woman to lie for what this right she has now, they could strip that, correct?
The amendment does say that the people of Kansas, through their elected representatives, will be able to make laws that have to do with abortion, as we have done. And so at the moment, there's a federal right to abortion. We can't supersede that. That is in place. So we cannot supersede that. And what do the people of Kansas want? We're just letting them vote through their representatives. So you're right. It could go either way, depending on who do we have as a governor? Who do we have as our legislators? You're right. It is a vote of the people through their legislators. So yes, but at the moment there is a right to abortion in the federal Constitution.
Representative, you are a litigator, is that correct?
I am an attorney, but I am not a litigator.
Have you litigated?
I have not, actually.
As an attorney, though, when somebody goes to court, the judge makes a ruling on that, and that's something that we abide by, correct?
Yes.
Okay.
Unless we appeal it to a higher court,
okay.
Yes.
And the judges in the Supreme Court, and we have a judge who chairs our committee, very wise, respected person, and usually
Yes.
comes up with good answers on suggestions and that, right?
Yes.
Okay. I see this happening to strip the judges who are approved by the Senate, elected officials on the far side, that make these decisions. We would be kind of, to me, this is kind of a vote of no confidence in that. That's my interpretation. Would you correct me on that?
So first I will say the Supreme Court is not, doesn't go through a Senate confirmation process in the state of Kansas. The appellate court, the middle court does, but not the Supreme Court. But I would say that the judges are not elected. They're very wise. They know a lot about the law, but they're not elected, and there's 7 of them, and they made this sweeping decision. And I really think, because we feel so passionately about it, that the people should be able to vote about.
Thank you for that. And then I'll end on this. I was watching online the other day, President Trump's spiritual advisor, her name is Paula White, praying to a mass of people that all satanic pregnancies should be miscarried. Can you tell me what a satanic pregnancy is? I don't know myself, don't know, and it's not my spiritual leader, but perhaps it's your party's spiritual leader or your president's spiritual leader. Can you elaborate on that?
I don't know her, and I have no idea what she was talking about. I hadn't heard that.
Okay. And then again, finally, why the primary election and not the general?
Okay, thank you for asking that question. A lot of thought and discussion went into that, and you know, August is our Kansas election. That's when we're talking about Kansas issues. And so it's best to be in Kansas. We all know that in November, there's going to be so many federal issues on the ballot. There's something called voter fatigue. The resolutions come at the very bottom of the ballot. As people are going through, could it get lost? It could. Could people get fatigued about voting? Yes, they could. So in August, everyone, and now independents, Democrats, Republicans, everyone has the opportunity to vote. It is a choice if you decide to vote in August. And that seems the time to talk about our Kansas issues.
And thank you for using that word choice. I will not be supporting the resolution, Mr. Chairman. Thank you. Thank you, Representative.
Chair recognizes Representative Carmichael.
Thank you, Mr. Chairman. The best place probably to start is to confess to you that I do have a bias in this. And I know each of us have our own personal stories. If it's not us personally, it's a friend, it's a family member, it's an acquaintance who's been touched for better or for worse by the Roe versus Wade decision. My friend of over 20 years was murdered in the narthex of Reformation Lutheran Church while his wife sat in the choir loft above and heard the shots. So please understand that I do have great emotion regarding this issue, perhaps for reasons different than each of you may have. That being said, I'm going to do my best this morning to try to go through the amendment and the applicable cases by only citing 4 cases. I could talk on this all day, but I want you to also know that I do not hold myself out as a constitutional scholar, nor as a legal scholar. I'm a practicing lawyer who was fortunate enough to come to this legislature 7 years ago. Perhaps a good starting place is to talk about a case called Griswold versus Connecticut. I haven't read that decision in many, many years, but it was a decision that came before Roe versus Wade. And Griswold dealt with a situation where some states prohibited the use of contraception. They may have prohibited that use because of social mores. They may have prohibited that use because of religious beliefs concerning whether sexual contact was for purposes of procreation only and in furtherance of the divine commandment to go forth and multiply. They may have prohibited contraception for the reason that some forms of contraception impede or prohibit a fertilized egg from implanting in the uterine wall, and some folks, for scientific, religious, or other reasons, believe that contraceptions abort a fertilized egg, and hence conception has occurred, and when man interferes with that implantation in the uterine wall, that is an abortion. The court in Griswold, though, took a look at the United States Constitution's 4th Amendment and 14th Amendment, and I don't want to be the legal scholar here, but what the court generally concluded was that not only women, but their partners and their families as well have a right to privacy, and that the government could only intrude upon that right to privacy if the government could show a compelling state interest and that the restriction or regulation or law to be imposed was, and I'm not using the right word today, but was the least invasive, if you will, alternative, so that we only abridge or restrict our right to privacy under compelling circumstances and only when the action of the legislature is essentially the only thing that can be done to accomplish that purpose. That decision has changed America. It has allowed women to move from a status where, upon becoming pregnant under circumstances that were I'm stepping ahead of myself. It's allowed women to, with reasonable probability, the opportunity to not become pregnant at times in their life when it would have adversely affected not only their lives and careers, but also that of their families. And I recognize that there are people still here today who do believe that the use of contraception is prohibited by their religion, there are people who also believe the use of contraception is in fact an abortion. Following that decision, I think we can move to the Roe versus Wade decision. Roe versus Wade established a trimester approach to when and whether the government could or could not regulate the termination of a pregnancy. The court there certainly looked to the Fourth Amendment right to privacy and the 14th Amendment right to due process, and a learned judge, I believe a judge appointed by Republicans and a man who was thought of to be a relatively conservative man, who also represented the Mayo Clinic prior to ascending to the bench. He developed, along with his colleagues, a 3-trimester approach. And in very simple language, what it said was that given the right to privacy, given the right that the right to privacy is a fundamental right, and we will talk about that in more detail momentarily, but given that circumstance, that it was appropriate during the first trimester of a pregnancy to allow the individual, the fundamental individual right to make determinations about not only conception, but also carrying a pregnancy. The court then undertook an examination that realized that at some point along the line, the standards should be stricter in order for a pregnancy to be terminated. And the court developed an additional 2-trimester approach with increasing permission to the state to regulate and virtually prohibit abortion as the trimesters went by, and at the same time imposing a higher burden on persons who wanted to terminate a pregnancy to justify the need or the necessity to do so. Much legal work was accomplished in between, but Chief Justice, no, she never became Chief Justice, but Justice Sandra Day O'Connor is attributed with the concept of the undue burden test, which is a test that that is the current test under the United States Constitution, and it essentially says that so long as a regulation on abortion does not impose an undue burden on a woman's right to terminate a pregnancy, the court will approve that regulation or law. That is the current status, I believe, of the federal law. We need to talk about a fundamental right, what a fundamental right means. The First Amendment to the United States Constitution is an excellent place to have that discussion. I am extremely pleased that I have a First Amendment right to practice my religion as I choose, not as you choose, not as the government chooses, not as the governor chooses, but as I choose. And should this legislature seek to impinge upon my First Amendment right to practice my religion, I have the court to protect me, and I have the Constitution to protect me. And so, should you seek to infringe upon my right to practice my religion, I will be at the courthouse door and I will look to the court, be at the court across the street or the court in Washington, to protect that fundamental right. Another fundamental right is the right to free speech. Not only my free speech, but yours as well. I would certainly hope that I will defend with as much vigor your right to say what you believe and what you think as I would defend my own. When the state seeks to impose upon individual rights, it is typically thought to be in derogation of the Bill of Rights. The Kansas Bill of Rights is in fact different than the United States Constitution's Bill of Rights. You know, one of the grand opportunities about serving in our legislature is that I was able to spend a day in October listening to people from both sides and frankly expressing my opinion. And that despite my personality, the chairman of the Federal and State Affairs Committee was kind, along with the chairman of Senate Judiciary, to allow me to participate in their proceedings. So I've had a little bit of time to listen to arguments, but one of the things that I certainly learned is the Kansas Constitution is actually different than the United States Constitution. The United States Constitution, of course, was the product of compromise, and a constitution was written, but as a condition of members voting for that constitution, there was also an agreement to perfect a Bill of Rights. That is the first 10 amendments to the United States Constitution. And what is different about a Bill of Rights than a constitution is that a Bill of Rights protects individual rights, be that your right to your religion, be that your right to speech, be that your right to privacy, or yes, even the right of the press to say things about us which we do not like. But that is a fundamental right, and those are granted by a Bill of Rights. The Kansas Constitution actually is different. Unlike the federal Constitution, our Bill of Rights is a part of the state constitution, and in fact, the Bill of Rights appears at the beginning of our Constitution. Hence, the decisions that we've been discussing here are probably under Section 1 of the state constitution. And by the time our Constitution was drafted, our Constitution is substantially different in many ways than the federal Constitution, and our Bill of Rights is substantially different. And one of those areas is what brings us here today. I understand that the explanation of this amendment says that the right to personal autonomy is a newly discovered right. I disagree with that. That right to personal autonomy has been discussed and known to legal scholars, lawyers, and philosophers probably before even the forming of our republic. And what our court found was that indeed our Bill of Rights gives us more fundamental rights than the United States Constitution does, and we should be happy about that. That's a good reason to be a Kansan, because unlike people in other states, we have a right to bodily autonomy. Now, I know in the context that we're in today that many of us do not like the fact that the court found not only a right to bodily autonomy, but also that that right encompassed the right to abortion. But that right also encompasses some things that I think many of you may find very important. For example, those of you who believe that individuals should not have to receive vaccinations. I think what the court recognized in the Hoday's decision may provide great help to you. Those of you who believe that we should have a right to choose medical treatments, I think you will find that right provides great comfort to you. Those who want to make end-of-life decisions, again, I think that right we will find will make us proud that we are Kansans. And when that fundamental right to personal autonomy is questioned or infringed upon by the state, in many of those circumstances you will be very glad that it is subject to the strict scrutiny standard. Just as all of us are very glad that legislation which impinges upon our right to practice our religion is also subject to the strict scrutiny standard because it is a fundamental right. The Hoday's decision did not come out of whole cloth. It was not discovered one day. The right to personal autonomy has been thought of for many years, as I said a moment ago. It was only that the issue was not directly presented to the court prior to the Hode's decision. It was not a newly discovered right. It was a recognized right, a right that existed from the day this Constitution was adopted by our forefathers, and it was recognized by the court in Hode's. Now, why does that become important to us? Well, the reason I think that it is of importance to all of us is that when we begin to chip away at a fundamental right, even though at the moment, perhaps a majority of the legislature, perhaps even a majority of the electorate believes at the moment it would be the right thing to do in this circumstance, the concept of putting fundamental rights to a vote of the majority or a two-thirds majority is a dangerous road to go down. There was a time in this country when the majority of people thought that African American people were, if not subhuman, certainly not entitled to the same rights as white people. There was a time in this country when the majority of Americans thought that gay people suffered from a mental defect, that they were morally corrupt, and accordingly, even in our state, we voted to prohibit marriage between gay Kansans. Well, we've seen what a constitution does because our court, the Supreme Court, found it to be a fundamental right. And I think all of our attitudes, mine included, have changed toward people who are homosexual. We've found that, protecting their rights did not infringe upon mine. And so the concept of putting individual rights, fundamental individual rights, recognized rights, established rights, up for a vote is what gives rise to the saying that a constitution protects the minority from the tyranny of the majority. Now, there are times in our history when changes need be made. Indeed, Kansas was one of the first states in the Union to provide for women's suffrage. Kansas was formed on the principle that slavery is wrong, even though at the time of founding of our republic, it was a given thing that black people don't vote, that for the census they're not counted the same as white people, and that women certainly should not be trusted with the vote. But times changed. So now we turn specifically to the subject of abortion and what this particular amendment does. And these remarks are extemporaneous today, but I did run off a copy of the exact words, and I'm not going to try to address the explanatory statements. Suffice to say, I have difficulty with those. But I want to talk to you specifically about some language that you will find in the actual words that will go into our Constitution should this amendment be adopted. And you will find those words at lines 19 through 27 of the concurrent resolution. The words in particular that I want to call your attention to at this point are the words that say the people, through their elected state representatives and state senators, may pass laws regarding abortion, including but not limited to in circumstances of pregnancy resulting from rape or incest or when necessary to save the life of the mother. When I first read that language, I wasn't sure what it meant. I actually thought it was bad drafting. I thought it was surplusage. But the more that I have looked, and as I listened to the debate in the Senate, I did realize what the purpose of that is. It says that even in cases of rape, incest, or when necessary to save the life of the mother, this body and the folks across the chamber may pass laws regarding abortion. That means we are specifically saying in cases of rape, incest, and even when necessary to save the life of the mother, the legislature may pass laws regulating abortion. The words of the amendment also clearly say that the state of Kansas, say the state of Kansas does not require government funding abortion and does not create or secure a right to abortion. So now we know that this constitutional amendment specifically provides that by a 50% plus one vote here, a 50% plus one vote over there, and arguably without any interaction by the governor by way of veto, that should this pass, we will be able to ban abortion in every circumstance, even in cases of rape, incest, or when necessary to save the life of the mother. That is what the words say. Now, I do not doubt the veracity of many of my friends who say, that's not what this means. That's not what we're going to do. And I understand that. But as a lawyer, I tell you, the black letter law is what controls, not our personal intent or our good faith amongst each other. It is the words that you put in the Constitution, and these words are abundantly clear, that should this become law, the Kansas legislature, without even an opportunity for the governor to veto, will have the power to ban all abortion in this state under every circumstance. That is exactly what this means. There were amendments offered in the Senate to change that. Those amendments were defeated. I have asked the revisers to prepare multiple amendments. I may or may not decide that we should go that route. We'll see where the debate goes. But we could fix that provision of this bill. We could. And our friends in the Senate, we know, have already rejected that approach. I hope that wasn't the president calling, Mr. Majority Leader. The president of the Senate, I meant. But in all seriousness, that type of amendment would probably be a poison pill because our colleagues in the Senate do not seem inclined to go that way. The final thing, though, and there's a lot more that could be said, but the final thing I want to talk to you about is this concept that the Hoday's decision somehow prevents health and safety regulations for medical clinics and or hospitals which provide abortion services. You remember we talked about fundamental rights and the First Amendment and how it's subject to the strict scrutiny standard? Even though it's strict scrutiny, I cannot shout fire in a crowded theater. Why? Because under the strict scrutiny standard, there is a compelling state interest in preventing me from doing that. And so the state can prevent me from shouting fire in a crowded theater, but the state cannot prevent me from discussing fires in crowded theaters, what we can do to stop that, what regulations we can pass for health and safety. One of the areas where the strict scrutiny standard has always been applied and yet still upheld is when we come to matters of health and safety. Medical treatment is critically one of those areas. I know that many of you have a fear that there will be no regulation on abortion clinics for health and safety and sanitation or misrepresentation. I understand you have those fears, but I would suggest to you that they are unjustified. I would suggest that because we have always, for example, under the First Amendment, even in the face of strict scrutiny, said, I can't lie about my friend or neighbor without being sued. I can't lie about my product. I can't misrepresent to you what I as a lawyer can or can't do or my qualifications. The medical profession is under no lesser standard. The Hoday's decision does not change that. But the reason that we have to discuss that today is the Hoday's decision is not final. It is in the district court in Topeka. I think it's very likely it will make its way over to the Court of Appeals again. It will probably make it to the Supreme Court again. The district court will be called upon to apply the fundamental right to personal autonomy to the circumstance of abortion. And it would surprise me very greatly, extremely greatly, if the court reaches out and also says, and by the way, there can be no regulation of abortion clinics or what abortion physicians say or how they treat their patients. That's not what the court is likely to decide. And so if we move quickly today and we move with haste and without judgment, we may find ourselves unnecessarily chipping away at a fundamental right to personal autonomy that we as Kansans enjoy. That is a reason that we can be proud to live together in this state. So I urge you, friends, use patience, use deliberation in your work here today. I understand that people, good friends of mine, have a very different opinion, but I urge you to use patience and accordingly vote no on SCR 1613, realizing that if the court does in fact do the things that some folks think the court will do, we'll be open for business next year. So I appreciate your time, your consideration, and thank you, Mr. Chairman.
Chair recognizes Representative Lusk.
Thank you, Mr. Speaker. It is only a matter of time until Roe v. Wade is repealed by the U.S. Supreme Court. Once that happens, it will be up to each state to decide, really decide, the abortion issue. And because of that, this amendment to our state constitution takes on a much greater significance. The way it is written is extremist. I mean, it is cleverly written to kind of disguise, I think, what the real purpose is, to mislead, but it is a Trojan horse. If Roe is repealed and this amendment is passed, any protected right for an abortion in Kansas will be permanently gone, even in cases of rape, incest, and high-risk danger to the life of the mother. That is what this debate is really about. And because of that, I want to explain the Christian pro-choice point of view on abortion. I've been in this legislature for 8 years, and to my knowledge, the Christian pro-choice point of view has never been brought up before, and it is relevant. Not every Christian believes that personhood begins with conception. Surprisingly, it was a religious argument that left me in complete doubt of when personhood begins. That doubt began years ago in a conversation about abortion with a dear friend from church. She told me what the Bible says in Exodus chapter 21, verses 22 to 24. It is the only passage in the Bible that speaks directly about the value of a fetal life compared to the value of a life of a person. It says if a woman is struck and dies, the offender must pay with his life, a life for a life. However, if a woman is struck and a miscarriage results, the offender would only pay a fine for the loss of the fetus. That raises a question. If the fetus and the woman are equal human beings, why is the punishment for taking the life of the fetus equal to the punishment for killing the woman? Apparently, the Bible does not consider the death of the fetus to be murder. The timing of ensoulment is the key, I think, in judging when a fertilized egg or a fetus becomes a person. When does the soul enter the body? Different faith traditions and religions have had a variety of beliefs throughout history on the timing of ensoulment. Some popes and other leaders of the early Catholic Church held that ensoulment did not happen before the stage of the quickening. And the quickening is when a pregnant woman first feels fetal movement. Many mainline Protestant denominations have issued pro-choice proclamations in the past 5 decades. An example is the United Church of Christ statement from the 8th General Synod in 1971. And if you look at other faiths, you will find, well, different points of view. There is a unanimous consensus among Muslim religious scholars in the Islamic tradition that ensoulment does take place 120 days from conception. The mainstream Jewish position is personhood begins at birth. And just this last week, I learned from my office mate that is also the belief of many Native American faith traditions. First Lady Barbara Bush is another example. Notes from her personal diaries on the subject were recently discovered by her biographer. These are her words. When does the soul enter the body is the number one question. Not when does life begin, as life begins in a flower or an animal with the first cell. So the question is, does the soul enter the body at conception or at the moment the first breath is taken? Barbara Bush ultimately decided that life began with the first independent breath. Perhaps Barbara Bush was inspired in her belief by the beautiful imagery of the biblical passage from Genesis chapter 2, verse 7. And the Lord God formed man of the dust of the ground and breathed into his nostrils the breath of life, and man became a living soul. Okay, I'm not a theologian, but to me, that verse sounds like a description of God delivering a soul into that body with his breath. I realize that there are critics online, pro-life critics, who would suggest that this interpretation of the Exodus chapter 21 verses is not correct. They would counter with other Bible verses often out of context to defend their belief that Scripture supports the idea that a fertilized egg is a human being. You know, verses like Jeremiah 1:5 and Psalms 139:13. I'm not eager to set up a battle of dueling interpretations of Bible verses, but I feel a need to explain why those verses, the I formed you in the womb verses, do not discredit the rationale that I take from Exodus 21, verses 22 to 24. First, if one looks at the totality of the 36 translations of the Exodus chapter 21 verses at www.BibleStudyTools.com, as I did, and not just a single cherry-picked word from a cherry-picked translation, as some online critics are prone to do, one would see that the predominant meaning of the verses in total is that the verses are speaking of a miscarriage and aborted fetus, and that the fetus does not meet the life for life standard. Second, there are other biblical scripture stakeholders in this debate besides Christians, a people whose faith is also based on the Old Testament, those of Jewish faith. Many Jews have a strong adverse reaction to the pro-life interpretations of verses like Jeremiah 1:5 and Psalms 139. I didn't know this until I ran across an article in USA Today last October with quotes from a Chicago rabbi named Dana Ruttenberg. She finds such interpretations problematic and even insulting. She complained, quote, "They're using sacred texts to justify taking away my rights in a way that is just so calculated and craven." The Jewish tradition has a distinctively different reading of the same text. Jews don't believe that fetuses have souls until birth, and therefore, terminating a pregnancy is no crime. The view Rabbi Ruttenberg expressed is a viewpoint of traditional Jewish law, and is based on several key texts, including Exodus 21 and Genesis 2, verse 7. It is also of note that Israel has some of the most liberal abortion laws in the world. Each woman in the Israeli army is given a free abortion at taxpayer expense if she wants one. In deciding who may have the superior edge in interpreting the Bible, it is good to remember that Israel has Hebrew as their national language. Okay, so I'd like to bring your attention to the chart that I had passed out to your desk. It is a Pew Research Center chart of American viewpoints on the legality of abortion by religious groups, and it frankly surprised me. The public debate on cable news and the newspapers and social media gives the impression that abortion is a settled question among those who are religious. But the chart shows there is no consensus among people of faith on whether abortion should be illegal. It's roughly 50-50. Religious arguments can inform our positions, but religious arguments alone cannot decide it. There is a lack of solid, undeniable scriptural basis for the absolute stance that abortion is murder. And no one can know with certainty, and no one knows with certainty when ensoulment takes place. And I'm really not here to say my interpretation is better than yours. I'm here to say there is too much reasonable doubt. Typically, when reasonable doubt exists in a case, the law in the U.S. weighs on the side of innocent for the accused. We have a high evidentiary criminal law standard in this country. For example, when a conviction in a jury trial is to be decided, all 12 jurors have to agree. Not a majority, or even 11-1, all 12. The burden of proof is on the state to prove guilt before I can endorse something that will eventually result in government restrictions that would take away a woman's reproductive rights. I have to be convinced beyond a reasonable doubt that it is the right thing to do. When an issue falls into the unknowns, as it does with this issue, I favor leaving the power with the individual to be self-governing instead of allowing government to impose its will. While the personhood status of a fertilized egg is very much in doubt, here is what we do know. We know with certainty that a woman is a person. As a Christian, I absolutely value the sanctity of potential human life, but it is not on par with the sanctity of a mother's life. With the growing viability of the fetus in the late stage of pregnancy, I will admit the issue shifts, and then the debate changes to the question of whose individual rights will prevail. Should it be the woman's or the fetus's? In setting priorities, I believe the value of the mother should not be subordinate to the value of the fetus. And that's my biggest worry. Drink. There are extremists, pro-life advocates who seek to prohibit abortions in any and all circumstances, like the founder of Live Action, Lila Rose, and the signers of the Dublin Declaration on Maternal Health Care. They say there are no legitimate medical situations where the mother's life would be enough at risk to warrant an abortion. That is not true. Women have died when denied an abortion, and here's an example. Savita, her name's a little bit hard to pronounce, but I'll give it a shot. Savita Parnavar was a pregnant woman from India who lived in Ireland in 2012. She was 20, let me back up. She was 17 weeks pregnant, she experienced back pain, and she checked into a hospital for help. After midnight, her water broke, but the fetus did not come out. She discussed the possibility of an abortion with the consulting physician, but the medical staff refused to perform an abortion, according to Irish law at the time. She then developed sepsis, a potentially deadly condition caused by the body's response to infection. She had a cardiac arrest, and she died at the age of 31. Her death became the focal point of public outrage against the abortion law in Ireland, and it was used as a rallying cry to repeal it with the Protection of Life During Pregnancy Act. If ever there was a country that was thought to have settled the abortion question, it was the Republic of Ireland, a 78% Catholic nation. Yet in 2018, they voted to change their law to allow patients access to a free and legal termination if their pregnancy is no more than 12 weeks. It is no longer seen as a black and white issue of protecting the unborn. The vote was 66.4% to 33.6%. Two-thirds vote. And this is a country that lived with a ban on abortion. I think that's why the vote was so high. So I struggled to try to think of some way I could kind of make this point, but explain it in a way that might reach more of you here. And so this is what I came up with. If an individual is in an active gun shooter situation under a perceived threat, in this country, we give that person the right to make a choice to defend his or her life. He or she may make their own judgment call as to whether the other person is a bona fide threat to their life or person. They may kill the other person if it is an act of self-defense. Okay, I hope you see the parallel. Second Amendment defenders do not trust government with restrictions on their gun rights. So it is equally understandable that women do not trust government with restrictions on their reproductive rights. It's a question of self-defense. I believe that a woman should have the right to choose life. If her life is threatened by a pregnancy complication, the power of self-determination and individual liberty should remain with the individual and not the government, especially in instances of reasonable doubt. HCR 5019 sets the stage to cancel all future reproductive rights for women after the repeal of Roe versus Wade. I cannot, in good conscience, support it. Okay. Well, I've talked a long time, and I thank you all for being patient. If it makes you feel any better, I really wanted to make this speech about 5 minutes longer. I wanted to address the false claim made by some extremist pro-life advocates that there is now scientific proof that personhood begins at conception. One big proponent of this claim is the Charlotte Lazier Institute. So if I would have taken the time, I would have explained how that claim falls apart upon examination. So please feel free to ask me about it later. Let me get one more drink. For many of us in this legislature, this issue is so hard. It's such a hard issue. I will confess it's been even harder for me this session because I chose to go kind of public in explaining my personal rationale for voting pro-choice. Last week, I had an editorial that ran in the Kansas City Star, and I gave testimony in the committee, so that's pretty public. The editorial was a condensed version of what I shared today. But last Friday, I received the nicest email in response to my editorial. It began this way. Don't worry, it's short. I'll get through it fast. Ms. Luss, for 40 years, I have been firmly pro-life. I have waited with all the open-mindedness I have to hear someone explain the pro-choice position with philosophical clarity. That kind of discussion is so rare that I had concluded it was not possible. But your piece, which led me to the link you provided, showed that the pro-choice position can be defended philosophically and intellectually. I'm not sure what to think now, but I don't mind being uncertain. I sincerely thank you for your effort to bridge the divide. Michael. I won't give his last name to spare his identity, but I will tell you what. After much research, reflection, and prayer, I am at peace with my no vote against this Trojan horse amendment. Thank you, Mr. Speaker.
Chair recognizes Representative Garber.
Thank you, Mr. Chairman. Would the carry the bill please stand for some questions?
Yes.
I think there are a majority of people here that believe that life begins when an egg is fertilized, commonly known as conception. Are you of that belief?
Please speak into the mic.
Pardon?
Please speak into the mic.
Okay. Let me try that again. I would say that the majority of people here believe that life begins when the female egg is fertilized, what is commonly known as conception. You believe that?
I believe life begins at conception, but I also don't think that's what we're here talking about today.
Now, what did you say?
I don't think that's what we're.
Okay.
I don't
right.
think that's what we're here to talk about today.
Okay.
Is that it?
That's it.
Okay.
Thank you. I certainly believe the case, and everybody who's been here long enough to know me know that I'm a very strong pro-life, that someone has to speak for the 60 million babies who have been killed in our nation since Roe v. Wade, which, by the way, I believe is an unconstitutional law, and we should have stood up to it many, many years ago. And I believe, and it's an interpretation just like the previous speaker, that the Kansas Bill of Rights secures the right to life for the unborn. Therefore, I have an amendment.
The amendment appears lengthy. Would you care to explain your amendment?
Yes, Mr. Chairman, thank you. This amendment removes the language that is currently in SCR 1613, and it replaces it with the language from House Concurrent Resolution 5004, which has been offered for the last 10 years. And what it does is it changes the wording in the Bill of Rights, Section 1, to say, this is the current language, all men are possessed of equal and inalienable natural rights, among which are life, liberty, and pursuit of happiness. This would add recognizing the authority of the state of Kansas to exercise its police power and its sovereign right to adopt individual liberties in the Constitution of the state of Kansas, more expansive than those conferred by the Constitution of the United States. The state of Kansas shall hereby guarantee the inalienable rights, equal protection, and due process of law of every human being from the beginning of biological development of that human being, including fertilization.
Is there objection to waiving the reading of the amendment? There is objection. The clerk will read.
Page 1 by striking all in line 7 through 10, in line 17 after the colon by inserting section 1 of, in line 18 by striking by adding a new section, in line 19 by striking 22 regulation of abortion because Kansas value, by striking all in lines 20 through 26, in line 27 by striking all before the quotation mark and inserting number 1 equal rights. All men are possessed of equal and inalienable natural rights, among which are life, liberty, and the pursuit of happiness, recognizing the authority of the state of Kansas to exercise its police power and its sovereign right to adopt individual liberties in the Constitution of the state of Kansas, more expansive than those conferred by the Constitution of the United States. The state of Kansas shall hereby guarantee the inalienable rights, equal protection, and due process of law of every human being from the beginning of the biological development of that human being, including fertilization. Also on page 1 in line 30 by striking all after the period, by striking all in lines 31 through 34 and inserting. The purpose of this amendment is to expand the class of human beings who currently enjoy inalienable rights, equal protection, and due process of the law under the Constitution of the state of Kansas to every human being from the beginning of the biological development of that human being, including fertilization. Also on page 1 in line 35 by striking all after 4, by striking all in line 36. On page 2 by striking all in lines 1 through 3 and inserting. This proposition would amend the Kansas Constitution to explicitly incorporate into it the inalienable right to every life.
The objection has been raised. Chair recognizes Representative Humphreys.
Thank you, Mr. Chair. I would like to challenge the germaneness of this amendment.
The germaneness has been challenged. Rules Chair will come forward and the Rules Committee will make a determination. body will come back to order. Chair recognizes Rules Chair Finch.
Thank you, Mr. Chairman, members of the body. Sorry that took a minute. We wanted to make sure that we gave this the full and fair consideration that it deserves. The underlying resolution is a resolution amending the Kansas Constitution to allow for the regulation of abortion. It says that the people, through their legislature, shall have the power to do that, subject to federal jurisprudence springing from the federal Constitution. And the amendment recognizes certain rights that go well beyond the federal Constitution, invokes state police power, rights of due process and equal protection, and extends those rights to every human being at the point of fertilization. On the one hand, the underlying bill allows for the regulation of the practice of abortion. The amendment expands the scope of rights and includes all people, whether born or unborn, to the grave at any age, and is far more expansive than the underlying bill. You'll recall that we have enunciated a two-factor test in the past, and we have said if the underlying bill is narrow and the amendment would broaden in scope the issue being debated, that we do not find that there is a germane amendment. In this case, we go from a fairly narrow question of regulation of abortion to a much broader question about state sovereignty, rights to be extended, and to whom those rights are guaranteed. And for that reason, the committee was unanimous in its decision that this amendment is overly broad compared to the underlying bill and is not germane.
Representative Garber.
I respect the process that we have in this chamber, so I will not challenge the germaneness, but I do have a few more things to say. I hope when we vote for this, SCR 1613, that it passes, because I believe it needs to be in place. However, my heart grieves for those babies who will still be killed every day in our state. Those of you who are born after the Roe v. Wade decision have lost 1/3 of your generation to abortion. That's a sobering thought to me. On January 17th of this year, a message from Bob Dole was laid on our desk. One line from that message read, Kansas has always been a state where common sense and values rule. A few days later, on the 23rd, several members of this body honored civil rights leader Dr. Martin Luther King by sharing some of his quotes. One of them was, "Justice too long delayed is justice denied." Where is the justice for the innocent children who have been systematically removed from their mother's womb and thrown in the trash? Thank you, Mr. Chairman.
Chair recognizes Representative Williams.
Thank you, Mr. Chair. Well, it's about 6,000 babies that die in Kansas annually. It's about perhaps making it less than that. It's not about overturning Roe versus Wade. It's making sure that two interests are considered. It's making sure that the woman and the child is considered. If this constitutional amendment can protect even just one, or if it can even protect the woman's right to be informed, if it can provide consent or notification to the parent, why would we want to risk losing any of those things? Why not just ask the people? We've heard various representatives share opinions on religious issues and scripture, and I just wanted to mention one that I thought was kind of relevant. You know, in the Old Testament, there were 613 different laws, and some of those were civil or ceremonial or moral, but they weren't always just because they were God's will. They were put there for other reasons as well. In fact, if we want to talk about that for just a moment, Jesus said, hey, it is because of your hardened heart that divorce is allowed. So trying to use an Old Testament reference for the reason why we can justify this might not be the best. Maybe for those of us that are supporting it is simply because it says the moral code is do not kill. And we should preserve life whenever we can. And this constitutional amendment does not take away the right of the woman that was established in Roe versus Wade. It takes it back to the voters so that the voters may say, yes, reasonable laws may be issued through the elected process of our representatives. And that's a way to err on the side of caution, that our citizens have this opportunity. So for that reason, I'll be voting for life. Thank you.
Chair recognizes Representative Wynn.
Thank you, Mr. Chair. And I'll ask that you refocus on what the chair of the Rules Committee just said, that this is about regulation of abortions. I stand in opposition to SCR 1613 for 3 simple but significant reasons. One, now you can call yourself a politician or you can call yourself a public servant, whichever one you want. What you can't call yourself is a trained medical professional, other than a couple of us, a couple of you all, not me. And in my 20 years here, there have only been a couple. So that's one reason. I brought him in, I included him, that there's a couple of trained medical professions in this building, but that we're politicians. We have no right. We have no knowledge. We have no business getting into medical decisions. Number 2, this constitutional amendment would strip Kansas women of their right to make their own deeply personal medical decisions. And those decisions belong to those women, their partners, their family, their faith, deliverers, not the politicians in Topeka. Finally, its passage would be detrimental to the health and rights of women across this state, as well as set a dangerous precedent in big government interference. And as a side note, over the last 20 years, I've seen us pass rotten legislation. Legislation that was medically incorrect. Legislation that we have had to spend millions as a result of. We don't need to go down that path. I stand in opposition of SCR 1613, and I ask that you vote no. Thank you.
Does anyone else wish to speak to the SCR 1613? Chair recognizes Representative Clayton.
Hi, Body. We've heard some discussions on this issue, and now our debate is drawing to a conclusion. So what do we know? I really didn't think that I'd have to bring up the Maya Angelou quote, but I'm going there. When someone shows you who they are, believe them the first time. Today, we saw an amendment that was brought to this bill that shows us what the true intention is of those who brought it. That amendment is what the end game looks like. This is why we must vote no. This legislation is flawed and it's dangerous. A previous speaker mentioned that there were women that had died from back alley abortions. And that speaker stated that she didn't want any more of those to occur. And I could not agree more, which is why I will vote no. But above all, this legislation strips the constitutional rights from Kansans who can become pregnant. It's a small subset of Kansans, but it is an important subset, and we should not treat them differently. That is not how our Constitution was intended to work. We are all people, and our job as legislators is to focus on preserving and protecting the rights of our constituents, and that includes Kansans who can get pregnant. It is time for us to serve as a check to the Senate once again, and I am proud to stand in the body that will make the reasonable, measured, and appropriate decisions. I trust my colleagues, I trust you all to do the right thing, and I urge you to vote no on SCR 1613. Thank you, Mr. Chair.
Chair recognizes Representative Blex.
Thank you, Mr. Chair. I'm going to make this real short. When we abandon our principles, we lose the argument. And fellow colleagues, I'm asking you not to abandon our constitutional principles, and I urge you to stand with me in support of this constitutional resolution. Thank you.
Does anyone else wish to speak to SCR 1613? Seeing none, Representative Humphreys, you may close.
Thank you, Mr. Chair. First, I just want to say we are not here today to discuss the morality of abortion. That is not what this is about. We have a right to abortion under the federal Constitution. That is set in stone. But a morality question that I need to ask you is, isn't the thought of unregulated abortion repugnant to everyone in this chamber? We need and want women to have licensing, informed consent, parental consent, 24-hour waiting periods. These are really important. We need to keep those in place. A wise person said that he or she that is faithful in that which is least is faithful also in much. Not that any of the bills that we previously passed were least. By any stretch of the imagination, they were very important, the regulations. Many of you voted for them. Many of you were here and you voted for them. Those that protect the health and safety of the most vulnerable, they need to stay on firm footing. So if you are not sure how you're voting, if you are pro-life, and even if you are pro-choice, you can vote yes today. Because this vote doesn't change the legality of abortion in our state. You can vote yes because you care about women, because you care about the unborn, because you want reasonable regulations in place. And you can vote yes today, especially because in this vote today, we are simply tossing that question to the people of Kansas. Trust the people of Kansas. Mr. Chair, I move that when the committee rises and reports, it reports SCR 1613 favorably for passage.
You've heard the motion by Representative Humphreys to report SCR 1613 favorably. All in favor signify by saying aye. Aye. Opposed, nay. No. Roll call has been asked for. Seeing 15 hands, a roll call is in order. The clerk will open the roll and you may vote. Has every member had an opportunity to vote? Clerk will close the roll. Does any member wish to change their vote? Eighty have voted in favor, 41 against. The motion passes. The clerk will record the vote. Next item of business is House Bill 2467. For the purposes of carrying House Bill 2467, the chair recognizes Representative Hoheisel.
Thank you, Mr. Chair. Body, I bring to you today House Bill 2467 from the Committee on the Judiciary. HB 2467 would amend the definition of the crime of sexual battery to remove the element requiring the crime to be committed against the victim who is not the spouse of the offender. KSA 21-5505 currently reads, sexual battery is the touching of a victim who is not the spouse of the offender, who is 16 or more years of age and who does not consent thereto with the intent to arouse or satisfy the sexual desires of another. What this means is under current Kansas law, it is legal for a husband or wife to commit sexual battery against their spouse. Kansas has removed spousal exceptions for other sexual offenses in the past, and it's time we remove this exception as well. HB 2467 passed out of the committee unanimously with 0 opposition testimony. With that, Mr. Chair, I'll stand for any questions.
Chair recognizes Representative Parker.
Thank you, Mr. Chairman. And I thank the carrier of the bill. He did an excellent job describing this. I agree with what he says and would urge you to support this bill and thank the Judiciary Committee for working this last year and this year. I urge you to vote yes. Thank you, Mr. Chairman.
Chair recognizes Representative Holcher.
I do have a question for the presenter of the bill.
Yes, ma'am.
Do you know if there's anything in this bill that addresses, do you know if there's anything in this bill that addresses the time frame as far as when an intervention or assessment program starts?
1 second, let me confer with my chair here on that.
Okay.
Does anyone else wish to speak to the bill?
Representative, I see nothing in here that refers to a time frame. If you could point it out to me, that'd be great. I don't see anything that does though.
Yeah, I don't think that there is, and I am working on an amendment over here that should be friendly to this. What happens in these situations of domestic violence is after a second or third offense, it is typically recommended to have an assessment, essentially to take a look at the situation, see if therapy or something is recommended for the person who has been accused. Currently, the way the law works is after the second or third situation is when that recommendation is made to have the assessment. This amendment would say after the first situation, because if we're trying to prevent, then it potentially makes more sense to have the assessment and the intervention done after the first situation.
Okay.
So I don't think that is in there.
Okay.
Is there further discussion on the bill? If there's no... You have an amendment? Okay. I didn't see she had an amendment. Thank you.
Thank you for bearing with me, body, as we got things together there. As I mentioned briefly, this amendment only addresses the situation of where we have somebody who has been accused of domestic violence, where we have the situation where not only have they been accused and arrested once, but twice or even a third time. We do have a program set up by the Attorney General's office that
Pardon
tries
me,
to
Representative, you need to announce that you have an amendment.
Oh, I thought I did earlier, but okay, yes, I do have an amendment.
Okay? And you're explaining your amendment. It appears long, so go ahead.
Okay. Again, what this will do then is on, instead of the second or third offense of having intervention and trying to get therapy, counseling, and things to prevent it from happening again, the intervention comes after the first offense. So we already do this. This is just changing the timeframes to hopefully better impact the situation and reduce the incidence again of domestic violence. I'll stand for questions.
Is there objection to waiving the reading of the amendment? There is objection. The clerk will read.
On page 1, following line 5, by inserting Section 1 KSA 2019-2154-14 is hereby amended to read as follows. A, domestic battery is, number 1, knowingly or recklessly causing bodily harm to a person with whom the offender is involved or has been involved in a dating relationship or a family or household member, or number 2, knowingly causing physical contact with a person with whom the offender is involved or has been involved in a dating relationship or a family or household member, when done in a rude, insulting, or angry manner. B, aggravated domestic battery is, number 1, knowingly impeding the normal breathing or circulation of the blood by applying pressure on the throat, neck, or chest of a person with whom the offender is involved or has been involved in a dating
The objection has been waived. Representative Hoheisel.
Body, I haven't really seen this amendment. I would prefer it to go through the committee process so we could study it further, but I will not object to it and leave it up to the will of the body on how you would vote on this. Thank you.
Does anyone else wish to speak to the amendment? Chair recognizes Representative Keither.
Thank you, Mr. Chairman. I certainly think this is a fine amendment. It is common sense. If we're walking down a pathway of destruction to get immediate help and intervention, maybe we can turn things around and this is not so much of a problem that we're having. So I think this is a great amendment. Let's move it forward and make this a better place for couples to get along and avoid this problem.
Any further discussion on the amendment? Seeing none. Representative, you may close on your amendment.
Thank you, Mr. Chair. In closing, I just want to remind everybody, this is already a process that is set up. This just changed the timeframes in which we bring attention to bringing help and aid to try to prevent it from happening again. We have a great system set up through the Attorney General's office that does this work for us. Again, it's just trying to make the difference in reducing incidences from reoccurring. Keep in mind that as we work with the victims in these cases, it isn't just them that we want to help. We do want to help with the person who has been accused. So again, we can get them the services that they need to help them develop other plans for controlling anger and other issues. I appreciate you letting me bring this forward and wanted to let you know that this bill was heard in part, I believe, a couple of years ago, but there was a larger section attached to it, so it did not move forward. But this part had several proponents and only one opponent who opposed the other portion of the bill that is not contained in this amendment. So with that, I ask for your support as we make a difference in trying to reduce domestic violence in our state. Thank you.
You've heard the motion by Representative Holscher to amend. All those in favor signify by saying aye. Aye. Opposed, nay. No. The ayes appear to have it. The ayes do have it. We're back on the bill. Does anyone else wish to speak to the bill? Chair recognizes Representative Wheeler.
Thank you, Mr. Chair, body. This bill that came up on consent calendar concerns sexual battery and removing the spousal exemption. This amendment completely substitutes another crime I'm sorry, the crime just slipped my mind, but it's essentially, I can't believe this just happened to me. In a spousal or an affinity relationship, it's a completely different crime. I think this should not pass. The bill that we passed removes the spousal exemption and sexual battery and is completely unrelated, in my opinion, not even germane to this issue. Domestic violence, by the way. I think we should vote no on this. I think the original bill was the best and it solved a problem in this state. This does nothing to make it any better. So I ask you to vote no.
Does anyone else wish to speak to the bill? Seeing none, Representative Hoheisel, you may close.
Thank you, Mr. Chair. Body, let's do right today by the men and women of Kansas. Let's vote for this bill and push Kansas forward in regards to sexual assault and sexual battery in Kansas. With that, Mr. Chair, I move that when the committee rises and reports, it reports House Bill 2467 as amended, favorable for passage. Thank you.
You've heard the motion by Representative Hoheisel to report House Bill 2467 favorably for passage as amended. All those in favor signify by saying aye. Aye. Opposed, no. No. The ayes appear to have it. The ayes do have it. Motion passes. This concludes general orders. The chair recognizes the majority leader.
Thank you, Mr. Chairman. I move we rise and report.
You've heard the motion to rise and report. All in favor signify by saying aye. Aye. Opposed, no. Motion passes.
The clerk will read the committee report.
Mr. Speaker, your Committee of the Whole recommends Senate Bill 155 be passed, House Bill 2467 be passed as amended, Senate Concurrent Resolution 1613 be adopted.
Speaker recognizes Representative Prayle.
Thank you, Mr. Speaker. I move the adoption of the Committee of the Whole report.
You've heard the motion to adopt the committee report. All in favor signify by saying aye. Aye. All opposed, no. The ayes have it, and the committee report is adopted. Reports of standing committees. The clerk will read.
Committee on Agriculture recommends House Bill 2437 to be amended and the bill be passed as amended.
Is there any objection to returning to that order of business, introduction of bills and concurrent resolutions? Seeing no objection, the clerk will read.
House Bill number 2579 by the Committee on Health and Human Services, an act concerning health professions and practices relating to the Board of Pharmacy, Prescription Monitoring Program Act pertaining to persons permitted to receive program data, data security, user and delegate access. House Bill number 2580 by Representative Dove, an act concerning cities relating to annexation of territory. House Bill number 2581 by Representative Dove, an act concerning zoning and subdivision regulations requiring an election in certain instances. House Bill number 2582 by the Committee on K-12 Education Budget, an act concerning education relating to the Kansas School Equity and Enhancement Act, creating the Behavioral Health Intervention Weighting. House Bill number 2583 by the Committee on Local Government, an act concerning cities relating to vacation of territory or easements. House Bill number 2584 by the Committee on Local Government, an act concerning minimum wage laws permitting cities, counties, and local governments to set the minimum wage above federal or state levels by ordinance, resolution, or law. House Bill number 2585 by the Committee on Energy, Utilities, Telecommunication, an act concerning electric public utilities relating to the State Corporation Commission, exempting retail sales of electricity through electric vehicle charging stations from commission jurisdiction. House Bill number 2586 by the Committee on Commerce, Labor, and Economic Development, an act concerning public employee and professional employees organizations relating to dues, commencement, and cessation of withholding of dues. House Bill number 2587 by the Committee on Judiciary, an act concerning the probate code relating to adoption, venue, agency adoptions. House Bill number 2588 by the Committee on Appropriations, an act concerning transportation, providing for the Forward Transportation Program.
Announcements. Representative Brandon Woodard will replace Representative John Alcala today only, February 6, 2020, on the House Taxation Committee. Representative Brett Parker will replace Representative Ponkawi Victors today only, February 6, 2020, on House Transportation. Representative Gail Finney will replace Representative Ponkawi Victors today only, February 6, 2020, on House Transportation and Public Safety Budget. Representative Jim Gartner will replace Representative Eileen Horn on the Joint Committee on State Building Construction, February 10th, 2020 only. Happy birthday to Representative Timish. Further announcements. Speaker would recognize Representative Rajas.
Thank you, Mr. Speaker. We're going to sing? No. Colleagues, it is Farm Bureau Day at the Capitol, and we have a slight change in plans. The lunch is here now in the Capitol building, so go downstairs 172 West for lunch with the Kansas Farm Bureau. Thank you, Mr. Speaker.
Representative Landwehr.
Thank you, Mr. Speaker. No Health and Human Services this afternoon, but heads up, Monday is the last day for those bill introductions, and we will be calling a meeting at the rail upon adjournment of the House.
Representative Hawkins for an announcement.
Thank you, Mr. Speaker. I just wanted to let everybody know that today is Pastors' Day here at the State House, so welcome our pastors when you see them.
Representative Carmichael.
Thank you, Mr. Speaker. I just want to let you know the Kansas trial lawyers are hosting lunch at the Visitors Center today. I know there's many other things to do, but if you want some free legal advice, it's worth what you pay for it. Thank you, Mr. Speaker.
Representative Vickery.
Thank you, Mr. Speaker Pro Tem. I just wanted to tell the body that when I came here, or when the mayor of Ottawa came here as an intern years ago, I first met him. I think he was the youngest mayor of Ottawa, and today is his birthday. Happy birthday.
Thank you, sir. Are there any further announcements? Seeing none, Speaker would recognize Majority Leader Hawkins for a motion to adjourn.
Thank you, Mr. Speaker. I move the House adjourn until Friday, February 7th at 9 a.m.
You've heard the motion. All in favor signify by saying aye. Aye. All opposed, nay. The ayes have it. We are adjourned.